This is an important update for anyone dealing with U.S. immigration in February 2026. Whether you are waiting for a green card, holding a visa, renewing an EAD, or planning international travel, several changes are now affecting how the system works. Some of these changes were expected. Others are catching people completely off guard. And while none of this means immigration has stopped, it does mean the process looks very different than it did even a few months ago. February 2026 marks a period of adjustment. Not one single announcement, not one single law, but multiple updates happening at the same time across green card processing, visas, work authorization, and travel-related enforcement. Many applicants are confused. They are asking, why is my case taking longer? Why did I receive a new type of notice? Why is travel suddenly more complicated? These questions are valid because the system is changing in ways that are not always clearly explained. This update is meant to clarify what is happening, what it means for different immigration categories, and how people are being affected right now. Let's start with green cards. Permanent residency remains available, but processing has become more layered. In February 2026, immigration officers are applying additional verification steps before final approvals are issued. This is happening across multiple green card categories: family-based cases, employment-based cases, adjustment of status, consular processing. Applicants are seeing more requests for evidence, not because they did something wrong, but because officers are required to confirm more details than before. Employment histories are being reviewed more carefully. Travel records are being cross-checked. Prior immigration filings are being re-examined. Even cases that were previously considered routine are now moving through additional review stages. This has led to longer timelines. Some cases that once took months are now taking longer than expected, and that delay is causing anxiety. It's important to understand that delay does not mean denial. It means verification. But verification requires patience. Another green card issue appearing in February 2026 is interview scheduling. Some applicants are being scheduled for interviews even when similar cases in the past were waived. Others are being called back for follow-up interviews after months of silence. This surprises many people. They assumed once biometrics were done, the rest would move automatically. That assumption no longer holds. Immigration officers are now encouraged to clarify details in person when possible. This is part of a broader effort to reduce errors before approval. Again, not a punishment, a precaution. But it does mean green card applicants must be prepared for more interaction with the system. Visa processing is also seeing noticeable changes in February 2026. Non-immigrant visas are still being issued, but the way cases are reviewed has become more deliberate. Applicants for work visas, student visas, visitor visas, and dependent visas are experiencing longer wait times and more follow-up questions. For employment-based visas, officers are paying closer attention to job duties, employer legitimacy, and worksite consistency. Petitions that were previously approved with minimal review are now being examined in more detail. This includes verifying whether job descriptions match actual business operations, whether employers remain active and compliant, and whether positions meet eligibility requirements. Applicants may notice additional requests asking employers to clarify details that were already provided in earlier filings. This does not mean the case is weak. It means officers are being asked to document decisions more thoroughly. For visitor visas, scrutiny has increased around travel intent. Consular officers are focusing more on ties to home countries, previous travel patterns, and compliance with prior entries. Applicants who traveled frequently in the past or stayed close to the maximum allowed time may face more questions than before. Again, this does not automatically mean denial. It means the system is emphasizing compliance history more heavily than before. Student visas are also being reviewed differently. Enrollment status, school accreditation, and program legitimacy are being verified more often. Students may receive requests to confirm continued attendance, academic progress, or financial support. This is especially true for students who transferred schools or changed programs. Dependent visas, including spouses and children, are also affected. Officers are cross-checking family relationships with prior records more closely. Marriage dates, living arrangements, and shared documentation are being reviewed for consistency. Small discrepancies that once passed unnoticed are now more likely to trigger follow-up. Turning to employment authorization documents, or EADs, February 2026 has brought both relief and frustration. On one hand, automatic extensions remain in place for certain categories. This allows some applicants to continue working legally while waiting for renewal. On the other hand, processing delays continue to affect thousands of people. Some EAD renewals are taking longer than expected, especially for applicants tied to adjustment of status or humanitarian categories. USCIS has stated that staffing and system upgrades are part of the reason for delays. But for applicants, the impact feels immediate and personal. Work interruptions, employer concerns, uncertainty. Applicants are advised to file renewals as early as allowed and keep copies of all receipt notices. Employers are also being reminded to recognize valid extensions when permitted by regulation. Travel updates are another major area of concern. International travel in February 2026 requires more preparation than before. Airlines, border officers, and immigration systems are coordinating more closely. Travelers with pending cases, expired documents with extensions, or complex histories are being reviewed more carefully at entry. This does not mean travel is prohibited, but it does mean travelers should carry all relevant documentation, approval notices, receipt notices, evidence of ongoing status. Border officers are asking more questions and taking more time to verify records. Some travelers report longer secondary inspections. This is not necessarily negative. It is part of enhanced verification. Another travel-related change involves re-entry timing. Travelers who spend extended periods abroad may be questioned more closely about residence and intent. This applies especially to green card holders and long-term visa holders. Maintaining ties to the United States is being emphasized more strongly. Biometrics appointments are also part of the February updates. USCIS continues to reuse biometrics in many cases, but new appointments are still being scheduled when records are outdated or incomplete. Applicants should monitor notices carefully and attend appointments promptly. Missing a biometrics appointment can delay a case significantly. Finally, communication from immigration agencies has become more digital. Online accounts, electronic notices, and updated tracking systems are being used more widely. Applicants who do not monitor their accounts regularly risk missing important updates. This shift toward digital communication is intended to improve efficiency, but it requires applicants to stay engaged. The overall theme of February 2026 is adjustment. Not shutdown, not crisis, adjustment. The system is tightening procedures, clarifying records, and verifying details more carefully. For applicants, patience and preparation are more important than ever. Another area seeing quiet but important change in February 2026 is how immigration agencies handle backlogs and case prioritization. For a long time, applicants assumed cases were processed strictly in the order they were received. That is no longer fully true. USCIS is now prioritizing certain case types based on policy goals, staffing availability, and national workload distribution. This means two applicants who filed around the same time may experience very different timelines. Cases tied to employment continuity, humanitarian needs, or government deadlines may move faster. Others may wait longer even if nothing is wrong with the case. This is frustrating, but it does not indicate bias or denial. It reflects a system balancing limited resources against growing demand. Another development in February 2026 is increased file transfers between service centers. Applicants may notice their case moving from one location to another. This is done to redistribute workload and reduce extreme backlogs. However, transfers can temporarily slow processing as files are re-entered and reassigned. Applicants often worry when they see this happen. but in most cases, it is a neutral administrative step. There are also changes in how USCIS evaluates prior compliance. Officers are now encouraged to look more carefully at an applicant's full immigration history. This includes timely departures, status extensions, employment authorization usage, compliance with visa conditions. Applicants who consistently followed rules in the past often benefit from this review. Those with unclear histories may be asked to clarify details. This does not mean old mistakes are automatically punished, but they may need to be explained. Another issue gaining attention in February is the treatment of pending applications during travel. Applicants with pending adjustment of status, change of status, or extension requests must be especially careful. Leaving the United States without proper authorization can still result in abandonment of certain applications. While this rule is not new, enforcement reminders are increasing. Applicants are being encouraged to confirm travel eligibility before making plans. Even experienced travelers are double-checking now. Airports and ports of entry are also using upgraded systems. Officers have quicker access to pending case information. This reduces errors, but also increases scrutiny. A traveler's answers must match what appears in the system. Inconsistencies, even unintentional ones, can lead to longer inspections. Another development involves communication delays. While agencies are moving toward digital systems, not all applicants receive notices at the same speed. Mail delays, account access issues, and technical glitches are still occurring. Applicants are encouraged to keep copies of everything and track deadlines independently. Relying on a single notification method can be risky. For employers, February 2026 brings reminders about compliance. Worksite inspections, document verification, and employment eligibility checks continue to occur. Employers sponsoring workers are being reminded to maintain accurate records and respond promptly to government inquiries. This affects workers directly. Employer delays or errors can impact an employee's case even when the employee has done everything right. Finally, there is growing emphasis on legal clarity. USCIS and consular officers are being instructed to document decisions thoroughly. This means more written explanations, more detailed notices, and more formal communication. While this may slow things down, it also improves transparency over time. Applicants can better understand why decisions are made and what steps are needed next. February 2026 is not a moment of closure. It is a moment of recalibration. The system is adjusting to new tools, new expectations, and increased demand. For immigrants, staying informed is essential. Another development becoming more visible in February 2026 is how immigration officers are handling discretion. Discretion has always existed in immigration law, but it is being applied more consistently now. Officers are being trained to document why discretion is used, rather than simply applying it quietly. For applicants, this can feel unsettling. Two cases may look similar on paper, yet one receives faster approval, while the other receives questions. The difference often comes down to how clearly the file tells a complete story. Applications that are well organized, consistent across filings, and supported by clear evidence are moving more smoothly. Files that require interpretation or assumptions are being slowed down. This is why applicants are seeing more structured requests for evidence. Officers are trying to eliminate ambiguity before making decisions. Another area drawing attention is how long-term non-immigrant visa holders are being evaluated. Individuals who have remained in the United States for many years on temporary visas are seeing closer review of their status history. Officers are asking, was each extension filed on time? Were work authorizations used correctly? Were there gaps or overlaps? This does not mean long-term presence is a problem, but it does mean the record must clearly show compliance at every stage. February 2026 has also brought subtle changes to how humanitarian cases are processed. Asylum-related applications, temporary protected status, and related benefits continue to be available. However, officers are balancing compassion with verification. Applicants may be asked to provide updated information even if their situation has not changed. This is part of ongoing eligibility checks. For people waiting on humanitarian relief, the waiting can feel especially heavy. But delays in these cases often reflect workload and policy review, not disbelief. Another change involves how immigration decisions are communicated. More decisions are now accompanied by detailed written explanations. While this may increase the time it takes to receive a final answer, it also provides clarity. Applicants are better able to understand what was approved, what was denied, and why. This transparency can be helpful, especially for those planning next steps. Appeals, motions, and refilings are also being processed differently. Officers are paying closer attention to whether issues were previously addressed or ignored. Repeated filings without addressing past concerns are less likely to succeed. This encourages applicants to resolve issues directly rather than hoping they will disappear. February 2026 also highlights the importance of timing. Filing windows matter more. Late filings, incomplete submissions, or rushed applications are more likely to be delayed. Applicants who plan ahead and submit complete packages are better positioned. Finally, there is increased emphasis on maintaining lawful status throughout the process. Even when applications are pending, applicants must continue to follow rules associated with their current status. Violations during a pending period can affect outcomes. The system expects consistency from start to finish. All of these developments point to one central theme. Immigration in February 2026 is more structured, more documented, and more deliberate. It is not closed, it is not inaccessible, but it does require attention. Another issue coming up more frequently in February 2026 is status transitions. Many immigrants move from one status to another over time: student to worker, worker to permanent resident, visitor to dependent. In the past, these transitions were often treated as separate chapters. Now, they are being evaluated as one continuous timeline. Officers are looking closely at whether each transition was handled correctly at the moment it occurred. They are reviewing whether a change of status was approved before work began, whether travel occurred during a pending change, whether activities matched the status held at the time. This level of review is new for many applicants. It does not mean transitions are prohibited. It means immigration wants to confirm that each step followed the rules in place at that moment. Another area receiving attention is unlawful presence calculations. These calculations have always mattered, but officers are now double-checking timelines more carefully. Even short gaps between statuses are being reviewed. Applicants who assumed small gaps were harmless may be asked to explain them. Again, this does not automatically lead to penalties, but it does require clarity. Documentation showing timely filings, receipts, and approvals has become more valuable than ever. February 2026 also brings attention to how immigration treats dependents when the primary applicant's situation changes. If a principal applicant changes jobs, extends status, or adjusts status, dependents must also remain compliant. Dependents are not automatically protected by the principal applicant's actions. This has always been true, but enforcement reminders are becoming more common. Families are being encouraged to track each person's status separately while ensuring timelines align. Another subtle but important change is how USCIS handles withdrawals and abandonments. Applicants sometimes choose to withdraw a case or allow it to lapse when plans change. In February 2026, officers are documenting these outcomes more clearly. A withdrawn or abandoned case may still appear in future reviews, not as a negative factor, but as part of the record. Applicants should understand that every filing leaves a footprint. That footprint does not disappear. It simply becomes part of the history. There is also increased focus on consistency across agencies. USCIS, consular offices, and border authorities are aligning records more closely. Information shared with one agency is more likely to be visible to another. This reduces conflicting decisions but increases the need for accuracy. Applicants can no longer assume that details given in one place will remain isolated. Finally, February 2026 highlights the importance of realistic expectations. Processing times are not uniform, communication is not always immediate. Outcomes are not guaranteed on a set schedule. Applicants who approach the system with patience and preparation are better positioned to navigate delays. Those who react with frustration or make rushed decisions often create new complications. Immigration remains possible. It remains functional, but it is more deliberate. One last area that deserves attention in February 2026 is planning forward, not just reacting to what's happening now. Many people approach immigration updates only when something goes wrong, a delay, a notice, a problem at the airport. But the people navigating the system most successfully are the ones who plan before pressure arrives. They review expiration dates early. They understand which documents matter at each stage. They avoid last-minute filings whenever possible. This matters more now because immigration systems are less flexible under time pressure. Late filings are harder to excuse. Incomplete submissions are slower to correct. And rushed decisions tend to create long-term consequences. Another important reality in February 2026 is that immigration is no longer isolated from daily life. Employment systems connect to immigration databases. Airlines connect to border systems. Government agencies share information more efficiently. That means small inconsistencies can surface unexpectedly. A mismatch in employment records, a travel history that doesn't align, a status assumption that no longer applies. None of these automatically mean trouble, but they do require explanation. An explanation is easier when records are organized and decisions are intentional. It's also important to recognize that immigration news moves faster than official guidance. Policies evolve, procedures adjust, enforcement priorities shift. Not every change comes with a headline. Often, the first sign of change is how cases are handled differently than before. This is why staying informed matters. Not through panic, not through rumors, but through understanding how the system behaves in real time. February 2026 is not about sudden shutdowns or sweeping bans. It is about refinement. Refinement of review processes, refinement of verification, refinement of expectations. For green card applicants, this means more documentation and patience. For visa holders, this means clearer compliance and planning. For EAD holders, this means early renewals and employer awareness. For travelers, this means preparation and consistency. Immigration remains possible. Opportunities remain open. But success increasingly depends on attention to detail. If there is one takeaway from this update, it is this. Immigration in 2026 rewards clarity. Clear records, clear timelines, clear intent. Those who move carefully and thoughtfully continue forward. Those who assume nothing has changed are the ones most surprised. This concludes the February 2026 U.S. Immigration Update. Stay informed, stay prepared, and move forward with confidence.